Well, hello everybody, and welcome to today's webinar, the second in the Hang Up Your Legal Boots series. My name is Shaun Jardine from Big Yellow Penguin. I would like to describe myself as a recovering solicitor. I retired from my firm last October and am now doing law firm consultancy. I'm delighted to have been joined by Mark Briegal. Say hello, Mark.
Hello, everybody.
And Mark is still in harness. He's still in harness. And he's if you've looked at the blurb that has prompted you to join this webinar, you will know that amongst the two of us, he is the one who's going to be doing most of the talking today, because he's a company commercial specialist, and he is a specialist in dealing with professional partnerships and their acquisition and disposal. Mark, would you say that's a fair summary?
Yeah, I think we do M&A in the legal sector. We do restructuring of law firms. 70% of our clients are other law firms, which is a really bizarre business model if you think about it. And we do partners in, partners out. I can say willingly or otherwise. And my partner Paul Bennett does a load of compliance and regulation stuff as well. So between us, it's the business of law firms that we specialise in.
Good. And how is the business of law firms? How is your working practices at the moment with this sector that at this time of year, professional indemnity insurance renewal time of the year, might be quite busy, I suspect?
It is, yes. I think I've got about 5 on the go at the moment. Mainly sales, got a few acquisitions, and we've been pretty busy all through lockdown. And people are looking to dispose. I was saying, we were chatting earlier, Shaun. I said I had one phone call a couple of weeks ago going, can we do this by the end of September? Which the answer is no, or certainly probably not.
Yeah.
So we're busy. There is, as there has been, a lot of restructuring in the market at the moment, and I think I've been talking for a few years about effectively the PII insurers being the regulator of last resort, on the grounds that the SRA aren't closing firms down, but the insurers are.
Absolutely. Well, I think before we get into the nuts and bolts of today, for those people who are participating in real life, we do have a Q&A button, and if you'd like to type your questions in there, I will keep an eye on the Q&A box and put those questions to Mark as and when they come in. I mentioned this is the second in the series of Hang Up Your Boots. We did an earlier event where we had Andrew Allen from Francis Clark dealing with law firm finances, etc. We had Tracy Calverley from her business, compliance business, Viv Williams from Viv Williams Consultancy, and we had Jenny Screech from Howden's, a PI broker. So we were hearing from those people about actually the mechanics of what you've got to do, or at least what you've got to think about if you want to hang up your legal boots. And it was really following on from that event that we thought, well, okay, so what do we do when law firms want to sell? And I thought, I know a man who knows about this subject, and I thought it's probably worth tapping up to see if he'd like to participate in a webinar, and I'm delighted to confirm that Mark has said yes, which is why you're here. So Mark, first things first, so exit options, what are they? What are they available to lawyers wanting to get out?
To lawyers, oh, well, there's a whole host of options. I suppose, the easiest option is, if you have some form of partnership, and I'll talk about partners, but partners could be people who are in partnership, who are members of an LLP, or potentially are owners and directors of limited company law firms. But the easiest thing is to have good succession planning and to have junior people who are going to buy into the equity and release the older partners so they can sail off into the sunset. So that's the ideal sort of scenario. And what we've seen over the years is rather a lot of people getting to that concept too late, at which point then there's nobody come up. Because I think what you find is that if you don't develop these people, your good people, and give them equity at a reasonably early time, they'll just get fed up and go somewhere else. So then, we've seen this partners in their 60s who are going, ooh, who have we got coming up who'd want to buy us out? And surprisingly, there isn't anybody there. So that is, I suppose, the starting point, is there somebody within the firm who can either just buy into the equity, become a partner, or potentially some form of MBO, as it were, management buyout. So that's your starting point.
Well, you'll be delighted to know that Andrew Allen was, you and he are exactly on the same page, and that was the first point that he said that is often overlooked. Please look at your own people. So that's wonderful.
Yeah, and develop your own people and have in place a succession planning, so that the good people can see that there is a means of progression and that it's worth buying into. I think that society moves on and law firms move on, and I think when some of us had pure grey hair, the concept when you were a junior lawyer was, oh well, I'll join a firm, I'll do well, and eventually I'll be admitted as a partner, and that will be the pinnacle of my career, at which point I'll then retire 20 years later. And I think there are people now going, actually it's much riskier. The profits aren't necessarily there. Do I want to buy into that model? Is it's not that nice sort of comfy model that it was 20, 30 years ago. So that does then become more difficult, and you then start looking at economies of scale, and we're looking at the concept as to the classic high street firm. Will they survive? Some will, the well managed ones, but there's a lot of, dare I say it, not very well managed small firms that just don't have a business model. And I think solicitors are trained to provide very good legal advice to their clients. They're not always trained to run a business, and too many forget that they're running a business, and you've got to run the business and all of that. So what we're then seeing, I think, is merger. Now, so first thing is just bring people in. If that's not possible, we can look at merger. Now, I suppose first thing to say about merger is there's no such thing as a merger. There is only an acquisition. I've seen one that was quite close to a merger, but there's normally one firm that is more dominant in the merged firm, but we always sell it to everyone as a merger because it sort of sounds better. But basically it's acquisition. But you then need, I suppose, you start to go, well, okay, if we're sat here and we don't see that this business that we're running is viable over the next 3, 5, 10 years, what are we going to do? I mean, your first start is looking at organic growth and actually doing some strategic planning, where someone like you, Shaun, can come in and look at it and go, what is your business model? What are your finances? What do the numbers look like? If you ran it in a slightly cleverer way, could you make it more profitable and then encourage people in? But then it's a case of, well, do we look to merge? But why? I'm very disappointed. I've not had a law firm merger fall over in about 4 or 5 years. And there was one a few months ago that fell over. And I was involved too late. That's my excuse. But actually, the culture mix between these two firms was never going to work. The firm that was selling was, had some issues. The firm that was buying them was a good firm, but the cultural fit of these two firms was so far away. And when they got into detailed negotiations, it was really, really struggling. So, coming together with another firm is great, though, if we're being a little bit rude, we sometimes say that, if you put two poorly performing small law firms together, what you end up with is one big poorly performing law firm.
You took the words right out of my mouth, because I was going to say that, but yeah.
So you've got to do something different. And why are we merging? What is the combined firm going to do? Have you got complementary service offerings that you can then offer a wider range of clients, a broader set of services? We can now do this as well as that. Or do you have complementary geographical areas? That can make sense if you're in a particular part of the country. Well, we've not got a branch in that town, so we can do that if we've got relationships with estate agents or whoever it is. That can work, but you've really got to think about what you're doing. So come back to the point, there's no such thing as a merger. You then got to go, well, are we going to go and acquire somebody who will make us bigger and more profitable? And you've then got all the economies of scale. We might need fewer accounts people, fewer marketing people, whatever. Or are we going to be acquired? And then,
I was going to say, but if you are acquired, this is a question that's coming from Dinesh. He asked, what are the SRA requirements on a merger? Does the firm taken over need to close under its SRA registration?
Yeah, there's a form that you send off to the SRA that says we are closing this business and its files have been transferred to the buyer.
Right.
And then, because you don't need to be registered by the SRA if you're not doing any legal business. I mean, this might be a point, we were having a little chat earlier, and, sort of the holy grail of being taken over is successor practice. You've got to have you want to have somebody to be your successor practice, because then they take over all the regulatory issues and any insurance claims. Now, I'm sure we'll come on at some point to talk about the dreaded runoff cover. Runoff cover is fine if you close your business down, but it's only for 6 years. Some insurers, I think, are beginning to look to extend that, but if you're a partner in a traditional partnership or sole trader, you bought runoff cover for no doubt an obscene amount of money. Some big claim comes in at 6 years and 1 month. You're stuffed, technical legal term there. So if you've got somebody who is going to become your successor practice, what that enables you to do as a seller is to sleep easy in your retirement. And so when I'm advising firms who are looking to sell, it's, we've got to get you the runoff cover, because if you've got the runoff cover in place, you've got to get the successor practice, you don't need the runoff cover, you're sort of free of that regulatory burden.
And Mark, there was something before we started the webinar. We were having a general chat, and you raised the question that flabbergasted me, but I think it is obvious. You've come across a reverse premium. Do you want to explain what that was?
Yeah. So I mean, I think we've talked about it. We go back to following this time. I know, sort out your succession internally, then look to merge, be it to be acquired or to acquire or to do some form of merger. Your final option is to close the firm down. But closing it down, if we just cover that very briefly, is a nightmare. Because firstly, everyone knows about runoff cover. And I've been saying when I talk about runoff cover, it's going to cost you 3 times your annual PII premium. I was talking to some brokers who said, well, it's slipping up actually, could be 3.5, 3 3/4, pushing 4. So it's hugely expensive. But don't forget, you've got staff probably, so you've got redundancy cost. You've probably got premises, so you've got lease break costs or dilapidations, and dilapse are a huge problem in law firm sales, because the classic sort of high street firm that have been in the tumble down high street premises for the last 50 years, and the dilapse are there, normally on a lease that is now where the freehold is owned by the widows and grandchildren of the founding partner, and so on. But that's another issue as to what we do with that. So you've got that, and then the one that people often forget is storage costs. You've got your basement full of files, or you're renting a warehouse, and it's not just the cost of the rent of the warehouse. If you're not there, and you can't send your office junior or your poor, put upon trainee to, go through the damp warehouse in search of that file that was closed 5.5 years ago, you've got to pay someone to store that and to have access to it. And that can be a real problem in it. So, the cost of closing down a law firm is immense. So that then brings us on to the concept of the reverse premium. And as you said, Shaun, I'd heard about this, but we actually did one about 18 months ago where a firm that was, basically they had nowhere to go, they had no succession, they had, financially it wasn't great. So the deal that was done with the buyer was, you come in, you take over, you become the successor practice, holy grail, it's what we want, and we'll leave some money in the office account to sweeten the deal. Because if we make a round number up 100,000 quid in the office account, that's significantly cheaper than us paying 300,000 or 400,000 for runoff cover, plus all those other costs around staff and premises and storage. So I'd heard about them before I did the one probably 18 months ago. I've now seen one. I wouldn't be surprised to see some more. And that comes back to this, get someone to become your successor practice if you can.
Yeah, absolutely. Well, yeah, it's slightly depressing, but yeah, I understand why with the economy. Well, in terms of what it costs to shut the business, it makes perfect sense. What about employee share ownership schemes? Are you coming across many of
Ah,
those? They're becoming increasingly popular. I still think there's probably more books written about it than there are firms that have done it.
I've done one. I've done one. Woohoo!
Oh,
Actually, I've
right,
done two. We've only got one over the line so far.
right.
Yeah, it's great. Now, my favourite quote, which I have to every time I speak to somebody, I have to get in, is the famous Peter Drucker quote that culture eats strategy for breakfast. And
Yeah,
when we're looking at all of this, we've done some interesting presentations around why law firm mergers fail. It's a cheerful subject. But the answer is culture. It's all about the culture. And EOTs are great if the culture of the firm is right. The one we did, which is public domain, um, great culture, really run well, great team spirit, great involvement. By handing it over to the team, they were bought into it, they loved it, it's going to be a success. If you're going down the EOT route purely because you go, I can get a slightly better price and I'll pay less tax, I suspect the chance of it falling over is going to be a lot higher. You still need somebody to run it,
mm,
is the issue. And if you've not got that succession planning in place, you can sell it to the OT. Who's going to run the business?
mm, absolutely,
But
absolutely.
now the sellers can, as long as they sell over 50%, they can take their money out. It's normally by means of an earn out over time, but they can stay and run it because as long as they're not the owners, they can be the directors of the trading company that's owned by the EOT. But obviously, they're at risk of the owners booting them out under the Companies Act. But yeah, EOTs I think are interesting. I'm reading certainly more about them in law firms. The John Lewis model.
Mm,
So if you've got the right culture and if you've got a good team who can run it, it is useful and certainly but going back, whilst it shouldn't be the main driver, there's some really interesting tax advantages to it. And because you're selling to a tame buyer, you'll be able to get a reasonable valuation probably
right.
without a third party buyer desperately trying to beat you down.
Yeah, yeah. Okay, all right. So,
Mm.
all right, we thought about warrants. How do we go about finding a buyer then? So we've got this law firm. We want to get somebody to give us some dosh for it. How do we're desperate to hang up our
Ah,
boots. How do
okay.
we find someone?
No, I want somebody to give us some dosh for it. So we'd have a little detour into whether or not there is goodwill in law firms. You know, it's they're very personal businesses. I think if you've got a scalable model where the people, as in if you're selling any business, if you've got a scalable model where the owners don't need to be there doing it day in day out, it's much more valuable than one that relies on the owners doing it. And
Yeah,
I'm having a little sort of detour into valuation as well. I often have slightly uncomfortable um, conversations with partners who want to sell, and it goes something like this. Well, what sort of valuation we get? Well, there's lots of ways of valuing firms, but if you come up with a number of sort of maintainable earnings, net maintainable profit over a 3-year basis, weighted possibly, apply a multiplier to it, lick finger 3, whatever. Okay. So these sort of go, all right, we'll do that. And we're making £150,000. 3 partners, we're making 150,000 a year net profit. We'll stick through on that. That's worth £500,000. Great. Yeah. Yeah. But what about your drawings? Because if you're not there, you're still doing work. So if we have to go out and employ 3 senior solicitors who can actually work, do the job, run a law firm, on that example, if we pay them 50,000 a year, which isn't a lot for somebody like that, suddenly your net maintainable profit is 0, and you can put whatever multiple you want onto 0, and
yeah,
you're going to get 0. So it's a goodwill, and what you're going to get for it is, and going back to what we were talking about earlier, leaving it too late you know that if you've got a fire sale, it's going to be much more difficult to get a good price. So what you need to then do is often useful to employ an outside broker to do this on your behalf. Do choose a good one. There are good ones. I know you had Viv on your last call, who's good. There's a few other good brokers. There are people out there who, if you give them your details, they'll just send an email to every law firm in the country, which is not what you want, because then your value dissipates instantly. But it's a case of looking at, well, what have we got here? What have we got that's worth selling? What might somebody want? Is it, some really good repeat clients? Is it some really good relationships with local estate agents or local, business people? What's coming in, and then what is that worth to somebody? And then thinking about, geography we touched on earlier. Is there a firm that have got sort of branches or branch offices all around us, but not in our town? They might want to get that. And do remember, in terms of, a firm doesn't have a value. There's lots of different values to potential different buyers. Any business has a range of different values. So who might be interested either in our geography, our work types, some of our key staff, some of our key relationships? If you know those people, and you've got a good relationship, there's one I'm working on at the moment that came about because the firm was thinking of doing this. There was a slightly bigger firm in their part of the country who'd let it be known that they'd be interested in acquiring. And one senior partner phoned the other senior partner, and they went for coffee, lunch, whatever, and things progressed from there. So you can do that. Or the other thing is that you appoint a broker who will then look at this. They will know all the firms and will be able to then come up with a short list, which they then have to discuss with the existing owners. How do you feel about them? Because it might be, over my dead body. I used to work with him or her in the past. So we ain't going. We're not getting into bed with them. But and then the other thing is that if you're using an independent, they can then make the approaches. Because if firm A phones firm B and says, "Do you want to buy me?" albeit slightly less subtly, you're on the market, are you? That's interesting. And then I'll just sit here and wait till it gets worse and then come in with a lower price. Whereas if respected broker phones firm B and says, "I've got a firm. Are you interested? These are the details." And it's an X sort of firm. It's turning over Y. It's got Z number of staff. So there's nothing given away. It's a firm in the home counties. With a nice general range of business, 4 partners, 25 staff. There's hundreds of firms that fit that. At which point you should produce a thing called really a teaser document, which is a 1-page that just sets out those key things. Based in county town, X number of staff. These are the past 5 years turnover and profits. These are the breakdown of areas. So again, nothing could give it away. You then go back and say, "Okay, are you interested?" Because that should be enough. You go, "Oh yeah, I want to know more." At which point, crucial. I know we're speaking to a bunch of lawyers here. Sign an NDA. So at that point, NDA goes out. Yes, that. Then you'll put together hopefully a broker. Again, a broker will be able to do this for you. Probably better an information memorandum, which is a sort of a 10 or 20-page document that sets out in a lot of details. This is the name of the firm. Actually, before you send that, you'll then, once they've signed the NDA, you'll phone back and go, "It's Blogs and Co. Are you still interested?" And occasionally I go, "Oh God, we know them. No thanks." Or, "Oh yeah, that's fine. Send me the IM." And you keep tight control on that. You should actually number them and send them to people. So the IM will set out in a lot of detail. This is who the firm is. This is their turnover. This is their profitability. This is their claims record, etc. So, and if they go, "Oh yeah, we're really interested," then you start with a facilitated meeting and discussing. And it was interesting. I always like the buyer to make the first offer. Right. What are you prepared to pay for this? they will, of course, will be saying, how much do you want for it?
Mm. Mm.
So, but that's the process. And then you're into negotiation with a view of then getting on to heads of terms and then the whole legal rigmarole that we will possibly move on to later.
Yeah, I think you make a very good point about specialist brokers. I'm acting for a client that is interested in will banks, and I spoke to one broker, and I was just fascinated to discover all they deal with is litigation and litigation books. I said, well, that's interesting. I said, because if my client comes across a firm that has got wills and litigation, we don't want the litigation.
Possible.
He said, oh, I'll have a chat with you. And it was very interesting about where there are these, horses for courses, but you've got to find out who they are, because otherwise you don't know. And I take your point entirely about sometimes if you end up on a mailing lists going out to, or Dalton's Weekly type website or something like that, where it's law firms for sale, that you've just got absolutely very little
and
control.
This stuff, and this stuff can be quite sensitive in terms of staff and so on. If staff go, ooh, is it closing down? Next time they get a call from a headhunter, they might be more interested to say, tell me about it, or so you do want to keep this reasonably tight as you go through the process.
Okay, so we've got to the stage where we found a broker, we've done our IM, we've danced around our handbags at an initial meeting and stuff like that. What's the anatomy of the deal going forward then? What does this look? You're talking to a litigator. I know I'm a litigator. I'm a non-practicing retired litigator. I don't want the SRA kidnapping my penguin or anything. But so what's the anatomy of a deal?
The anatomy of a deal is the conversations to get a decent heads of terms, which covers the main things, because that stops there being disagreements at a later stage. I mean, I think I did have one deal where when we got to version 17 of the heads of terms, I was going, do you really want to do the deal? Because culturally, these people you want to get into bed with, I know I'm being paid to negotiate them, but I'm getting really fed up here. They'll go through a period. So the key things, the key things you need to think about. Price. Is there a payment for goodwill? And what is it? And then what's happening to book debt? What's happening to WIP? There's lots of ways of accounting for WIP and who pays for it and when is it paid. And the other thing, of course, as with any deal, is is it cash now or is it an earn-out? And to be fair, probably 80% of what I see is earn-out these days. You will get your money over time.
Yeah. Is there a standard?
No, probably sort of 2 to 3 years sort of period, because what the acquirer is going to want is the seller to be around and to smooth that transition, to make sure the clients go to the new firm. Because I thought someone actually had asked the question about, do I have to tell my clients? Yes, you do, because your client files are privileged information that you as a solicitor have. You can't give them to somebody else without your client's permission. And without getting wildly technical in an hour, you certainly cannot transfer your client account balances to the buyer without the seller's, without the client's permission. So yes, you have to tell them. I've got. If anyone wanted to instruct me, I've got standard letters we can use on all of this. But you've got to get the permission there to do it. So the buyer wants to make sure, especially if it's not a commoditized firm, that all those relationships transfer over and all the people transfer over. So firstly you get what is the price and what are the terms, fairly obviously on that. Premises is often a real nightmare on this, which is, does the buyer want your current premises? Then on what basis do you occupy them? Which I'm often surprised. I'm not a property lawyer at all, but I go, how do you occupy your premises? And I would normally expect it's a freehold, it's a leasehold, and if it's a leasehold, this is the freeholder, and it's a 10-year lease that expires in 4 years' time. The number of times I get, well, not sure, it's really bizarre. I'll come on to the fact that if you do want to sell this, start now getting your ducks into order. Nothing puts a buyer off more than a seller who doesn't know basic stuff like, who owns the prop, on what basis do you occupy this property? Do all your staff have employment contracts?
Yeah, I with my wills client, we've approached verbs that said, well, how many wills have you got? Oh, not sure. How many of them are you appointed as executor? Nope, don't. And it's you can almost just feel the value going down.
Oh, absolutely. Yeah. How many of those people are still alive?
Yeah, absolutely. When was the last time you cleansed your database? Oh, didn't know you could do that. And it is frightening.
Yeah,
and it's such a shame because it impacts value so much.
Oh, it does, because the cost then of actually cleansing a wills database and actually writing out to everybody and saying, are you still alive? Is there a more recent will? And I know you buy it because you hope that they're then going to at some point pop off and you get a probate out of it, or of course you can then go, you did this 10 years ago, it's probably worth updating it, or and so on. But I have seen a lot of people thinking their wills banks are worth a lot of money because they've got 5,000 of them, but you ask those slightly sensible questions as to how many of them are actually real. And if they don't know, I'm thinking not a lot of value there.
No. Okay.
Or any value. If I'm acting for a buyer, I'm going, any value you've got there, I'm willing to pay you when it arrives.
Yeah, absolutely. And when these deals are being negotiated, what are some of the pros and cons that you might have come across, or where you think maybe there's an old saying that someone who acts for themselves has a fool for a client, isn't it? But I just wonder, in terms of whether there are any cases where you think, oh, that person shouldn't have done it that way, but I don't mind, I'm on the other side, so it's quite good.
Oh yeah, I've seen some buyers draft their own purchase agreements, and you sort of go, I'd have put that in. They haven't. Not my job to tell them.
No.
And stuff. So I mean, we go back. So obviously, the price for the entity. Then, of course, the majority of these are asset sales because, obviously, if it's a partnership, then the partnership will sell its assets. If it's a sole trader, it all has to do that. An LLP, in theory, the members of the LLP could sell their members' share to new people who would come in as the members of that LLP, and that LLP could continue. But to be fair, they normally just get sold out. I've done a couple of share sales where you've got limited company law firms. So obviously the advantage to the seller, if you sell the shares, it's easier and they can get much better tax relief. The downside for the buyer is, of course, they end up picking up all the liabilities of the company, in theory. Whereas if they just take the assets out, they leave the liabilities unless they're attached to the assets. So I don't see a lot of share sales with law firms, because you then end up having to run two parallel law firms with all the compliance issues of two parallel law firms. And if you've got a law firm that's then owned by another law firm, you have to license it as an ABS, because it's not run by.
Oh, right. Okay. Yeah.
I reckon 90% of what I do are asset purchases. So then, it's just looking through all the assets and making sure you get them across. You then get into the joys of TUPE and the staff.
Yeah.
The big question then is the owners, so who are maybe partners or members of the LLP, are they going to sail off into the sunset? Or are they then going to become members or directors or whatever in the buyer? And if so, on what terms and for how long. That's interesting. And if they're putting capital into the buyer, and you sometimes find this, well, you've got some capital in the in your current business, we'll take that in to the merged business, and you're going to become a partner in the merged business. You then get onto the subject of reverse due diligence.
Right.
Yeah, because I've got my 100 grand of capital in my business. I'm selling it to your business as the buyer, Shaun, and you said that's great. You can then have 100 grand of capital, and I go, well, what's my liabilities here? How well run is your business? We did one a few years ago where it was exactly that, and the buyer was good, but they had an annuity scheme for retired partners that everyone had to get into. That I remember the particular accountant, who was very good, described as a massive Ponzi scheme.
Did the deal go ahead, or did they run a mile?
The deal did go ahead on the basis that as long as this firm, which was quite a big firm and a successful firm, as long as it kept bringing in more partners every few years, then it was fine.
Yeah.
The risk was if more and more partners retired and new ones didn't come in, the person left at the end would, be having to pay annuities to 50 people.
Yeah. Okay. And again, this is me clearly demonstrating to our listeners that I am a litigator. In terms of the asset list, what are the typical things that if you were to say, right, okay, you're buying the assets of a law firm, what is it you're getting? What are you getting for your money?
Well, if you look at most law firms, the assets are, there's some desks, some chairs, some computer equipment. That's it, really, isn't it? So, and sadly, second-hand office equipment has zero value. So you normally end up, you either, look at, it's been written down to 50 grand in the account, so that's it, or we just agree a completely random number. What you're buying is, the client relationships and getting the staff cheaped across. So actually, back to culture. And I always say my job is the easy bit, and that ends when they've signed the deal.
Yeah.
Be it exchange or completion. The real hard work starts on integration. And actually, I was talking to somebody about this last week, that right, if this thing completes on the 30th of September, on the 1st of October, the senior partner, managing partner of the acquiring firm has got to be in there presenting to all the staff, going, wow, this is brilliant, this is amazing, your career prospects are better, we've got more of this, but we love what you've been doing, and really have a massive love in to keep them happy. Because if your staff go and your clients go in a law firm, you don't have anything.
No, absolutely. Okay, warranties, indemnities. There's a phrase that I have come across. So.
I think I've just got a phone call coming in. I'm going to have to take. Right. Okay. So now, at the risk of teaching a lot of grannies to suck eggs here, with a lot of lawyers watching, a warranty is a statement that, if not true, you have to put the buyer back into a position it would have been in. So classic warranty would be, there is no ongoing litigation. Fine. If it turns out there's a massive claim against the firm, you have to pay for that. And what you do with a warranty is you issue a disclosure letter against it. So, if it's a disclosure might say, a warranty might say, no staff have had excessive sick leave, in very general terms. And we could then disclose to say, Betty in accounts has been off for 6 weeks with X, Y, and Z expected back. Because what they can't then do is bring a claim against us. So that, so we have to, prepare. Going through the warranties is really tedious. You just have to go through them one by one and say, is there anything there, about this? And change of control provisions, photocopiers, going back to assets, because the photocopiers are probably leased. And I did nearly have a deal fall over the day before completion over a photocopier. Wow. So, who was going to pay this? The firm that was being acquired had, for reasons only known to itself, entered into some huge, long-term, expensive agreement to lease a photocopier that could, that was way too big for the firm. And the acquiring company, we don't want that or the liability. So, it's these things. Those things are going to be leased. There's a change of control provision in it. I mean, nobody will care because as long as you keep paying the monthly rental, companies are going to toss. But in theory, you've got to disclose all this. So you just have to go through those and disclose. And an indemnity is a specific pound for pound issue. So if we discover there is an ongoing employment claim by the bloke you dismissed unfairly 3 months ago, then we would, if I'm acting for the buyer, I put in an indemnity says, the sellers will pay the cost of any award to Fred Blocks, because we know that there's a claim there. I should say, in my career, I think I've seen 3 warranty claims.
Okay.
One involved an employee who wasn't disclosed, who we then dismissed, who then claimed unfair dismissal. Well, I say we, the client. That was quite fun. The second one involved, there was a share sale, and the seller took 50 grand out the account, the company's accounts, the day before completion. Which I had a very funny conversation with the seller solicitor. I said, he appears to have taken 50,000 quid out the account, the company's account. Now, you've not disclosed any dividends, so there's no paperwork. So it's not a dividend, not PAYE because that's not been disclosed. There's no paperwork showing that it's a loan. So the only other possible scenario is theft. So we won't go down that route if it's back in the account by tomorrow.
And I hope it was returned.
It was returned quite quickly. I'm trying to remember what the third one was, but they're rare, but they could be quite expensive. So you spend a lot of time looking at the disclosures. But if we go back to a stage, I was saying earlier, talking about due diligence, the first thing that will happen if you're looking to sell, once you've got the heads of terms sorted, is the buyer or the buyer solicitors will send through a due diligence questionnaire that says, tell me this, and this about all the contracts, all the employees, all of this. And if you've got a lovely set of documents that you can upload to a data room, and here's all the employee contracts in data order, and they're all complete. Here's our photocopy of contracts. Here's the contract with the cleaning company. Here's, all our PII forms for the last 5 years. The buyer goes, that's good. That's really useful. Everything's there. And if you're sort of going, we've got some employee contracts for some of the staff. And I've got a client, law firm, who's acquired quite a few. And I had 2 on at once a couple of years ago. And one was everything I asked, it came back and it was perfect. And I was just like, this is great. Look, we know everything about it. It's all good. The other one, after 3 months, we're still trying to find out the basis in which they occupy the premises. We don't have a full list. And eventually I said, this is a basket case. You're taking on a lot of risk here. If I were you, I'd walk away. So, if you're thinking of selling, start now in terms of that. And if everyone asks me, I'll happily send them a blank due diligence questionnaire so they can start looking at the things they're going to be asked.
I think that's a great opportunity, and I heartily recommend people to do that. Your contact details will be available as one of the last slides on this webinar.
Oh, that's good. Or else go on to PLC or Lexis. There's probably one there as well. But I do have one that's specifically related to law firm. Going back to that, by the way, I was talking about documents, and the key document, in my view, certainly when I'm acting for the buyer, are the PII renewal forms. I think that's a document that tells you pretty much everything you need to know about a law firm, assuming that the people who complete it haven't lied on it. It will give you the turnover, the profit, the breakdown of work, the number of staff, crucially, the number of claims. And what we're looking for when it comes, most law firms have a claim at some point. If a firm's had a claim, what we're looking for when it comes to claims is patterns. I had one where I go, you look at this over the last few years, there's been a whole series of claims in this particular department. That's a problem. If you take it over, there's a risk if more come through. Whereas one person in one department made a cock up on a file. Well, hand on heart, we've all done things that with hindsight we'd have done differently.
Okay, and what about the tax issues that people ought to bear in mind? This is where you rely on your terms and conditions to say we don't give tax advice, but
you've read my terms and conditions, Shaun.
I think it's every lawyer's standard terms and conditions. We don't do tax. Good Lord.
Yeah, mine also say we don't do property. My favourite page on our website is the list of things we don't do. Does say we know lots of really good lawyers who will do those. Tax, I think early on you want to get your accountant involved. And think about, if the difference between a share sale, if it's a limited company, and an asset sale, then it's just a case of looking at that and follow the flow of the money and where's the tax payable. If you're selling, if the LLP is selling, the proceeds go into the LLP and then they get distributed, as before. If you've got a limited company, if you take the proceeds into the limited company and then liquidate the limited company, that can be quite useful in terms of being tax efficient. I noticed someone had asked a question about
EOTs, who becomes the successor practice.
There isn't a successor practice because an EOT has to be the one we did. We had an LLP. So first of all, we had to make the LLP into a limited company, which is harder than it sounds. Get the limited company authorized by the SRA, and then we sold it to the EOT. So it's the same entity, but it then has to be re-registered as an ABS. So it becomes licensed as an ABS. The SRA were actually very useful on this, and we did the two at the same time. But it was this process. LLP business sold to limited company, which then becomes regulated by the SRA for several minutes, at which point the shares in the limited company get sold to the EOT. Actually, they get sold to a trust company that's appointed by the EOT, but this isn't an EOT talk. At which point it gets licensed, is the correct term, by the SRA as an ABS. There was a lot of paperwork to make it happen.
Good question, Mr. Raja there, but there we go. Dinesh has asked another question. I know.
I've spoken to Dinesh. If there's a sale halfway through the PPI year, what are the points to negotiate? Well, because that depends on whether or not you can get half your premium back, doesn't it? That's the big issue. And I've had some conversations in the last week or so, you can imagine, along the lines of, if we don't get this through in September and we end up having to do something in October, who pays? And I think that the answer to that is really, as in any negotiation, it's who's holding the cards on that. I've come across a lot of people don't get the second half of the premium back in that scenario. You've paid your premium, that's it.
And is that something that when you come up for renewal that you can negotiate that almost like a break clause with your insurer? I just wonder, is a question I could have put to Jenny Screech of Howden's last time.
Yes, I did a webinar with Jenny last year. She's very good. I was about to say, ask Jenny at Howden's. I think that's my view is that presumably all things are negotiable, and if you say actually I want it cancelable, I'm imagine it will be more expensive. But if you've got a deal that's looking hot, I say, I reckon 80 to 90% of the deals I'm involved in do progress through to completion. They all have a little hiccup somewhere along the way, but it's very rare that they fall over. And where they do fall over, mainly culture or leases.
Okay. And what other practical issues do you think that people need to bear in mind? Because the last question I'm going to ask you, just to let you know, is how long people should prepare for, because that was the last question I asked the previous panel. But that's
I
the
wish I
last
had a
question.
piece. Use my use my phone cable as the piece of string to say how long is it. I think actually, yeah, the two questions are linked together, Shaun, because I think what people underestimate is the amount of time it's going to take. Just not just the months, the elapsed months, but actually the full on. I always say to people, if I'm acting for them, especially on a sale, you're going to get really fed up with me because I'm going to be on the phone to you or emailing you twice a day. I need this, I need that. What about that? Tell me about that. There's an issue here. I need to know this. And often partners want to keep this stuff confidential, which is understandable. But if you've got a good practice manager, bring them in, share it with them, because they're going to be the person who will have access to all the documents that you need, the employment contracts, the PPI renewal forms, the photocopier contracts. I sound like I'm obsessed by photocopiers, but they're always an issue in these things.
Yeah, and do parties are electronic deal rooms very common now in these kind of transactions, or is it news to some people? There
are still lawyers out there, I'm sure, who dictate their emails. Electronic data rooms and actually, if you're using Microsoft 365, you can set one up in SharePoint.
Okay.
Yeah. We shouldn't use Dropbox because we don't know where it goes, or you can rent them. So electronic data rooms are fine. It makes sense. It's just so much easier.
Right. So if anybody is thinking, look, I want to hang up my legal boots. I've got a business that I want to sell. You're obviously the man to come and have a chat with, so that they can. Well, I'm sure. I'm sure there are other supermarkets, but you're one.
That's very kind of you to say. No, that's good. What I always say to people is pick the phone up, please not this one, and always happy to have a 15-minute chat to talk through the options with people.
Right. Well, look, Mark, thank you ever so much for your time. I'm just going to allow anyone, if anybody is thinking of typing another question in with 8 minutes to go, we'll deal with those. Mr. Raja again.
Oh, do you need to cross any GDPR issues for a data room? That is a really good question. What you shouldn't be putting up specific details in there. So what you should be putting up into your data room is anonymized contracts. So you should black out the names. Certainly, lists of clients should not go in there at this point. You'd have to anonymize them, large engineering company or whatever. You could talk about your relationships with particular providers, etc. But you do need to be careful about that. And that moves on to a more interesting question. There are specialist organizations out there who will do file reviews for you, which if you're buying is a really useful thing, because actually until you've actually picked up someone's file in an area that you know about and flicked through it, you don't know how good they are. And you then need to look at what your engagement letters say as to whether or not you can let somebody else do that. You normally can. There's ways around it.
Oh, that's interesting. So that if you are a buyer and you think, well, I'd just like to check out what's going on these litigation files or company commercials or property files, there are organisations who will wheel out some lawyers and send them in and say, have a look.
Yeah. Oh, absolutely.
What an interesting business. Oh, I might drop the line after that, Mark, and find out who those people are.
There's certainly, I know that the area where that was very big was in personal injury. There are definitely people who go and do that. And by the way, we've not talked about sale of books, which is interesting, because what we're also seeing now is where people take, I've done quite a number of sales where people go, actually, we don't want to be in personal injury anymore as a smallish firm because it's too difficult. And there's very specialist firms, who have the ability to do it, and they're going around hoovering up books of PI work.
Yeah. Also, I know there's some buyers out in the market. I haven't dealt with them myself. But criminal legal aid franchises where people are thinking, yes, I do want them. And I thought, wow, that's interesting, because nobody did.
Well, I think you can get some economies of scale on them, and that you then need to novate contracts, which is all very exciting.
Great.
For another day.
Yeah, absolutely. Well, Mark, look, thank you very much for your time. I did warn you in advance that when we say goodbye, when Marie hits the button, this cuts off very quickly. So we will take the opportunity to thank everybody for listening, and we will give you a wave to say goodbye. And
Zoom wave. But
thank you very much for
thanks for inviting me. That's been fun.
Lovely. Okay, I'll see you soon, my friend. Thank you. Bye-bye.
Okay, bye. Bye.